Testing 1 2. Testing 1 2. Testing 1 2. Testing 1 2. All right, what's up, everybody? SupremeDecisions here, and don't forget, super chat's open. Donations are in the link, and if you need a contact or a consultation, that's in the description as well. Now, actually, I've had an interesting day today, and I wasn't sure what I was actually going to bring to you today. At least not first, anyway, because I've got a few that I'm gonna do today, but it's today has been interesting to say the least, because I had a couple of banking issues, which was, again, interesting, because most of you know that I did have identity theft that happened, I want to say earlier this year, and I am still dealing with that. But the funniest thing is right now is, you know what, that's another video. But again, the next part of the interesting day I'm having is I had a question that was posed to me, and it was posed to me on one of my other channels. And I was like, oh my God, this is a phenomenal question, because it brought to mind the blue flu in Atlanta for Fulton County, brought to mind the coffee city where they was writing and creating more than $1 million of revenue here in Texas for a city with only 250 people in it. And all 50 of the police officers were bad cops. It brought to mind the, 84 officers in Buffalo that quit because they couldn't abuse people. Brought to mind the 96% of Minnesota police officers that are bad officers. And again, that's what this question brought to mind. And basically, it was just as you see on the screen. Can police be sued under the CCE Act, which is the Continuing Criminal Enterprise Act? And I'm going to explain the act, and I'm going to give you other information about it, because it's codified as 21 USC 848. The statute is sometimes referred to as the Kingpins statute. Now, let's break it down. What is a continuing criminal enterprise? Now, I'm going to read something and then I'm going to say something, so pay attention. The CCE Act is a federal law designed to go after large-scale, high-level drug traffickers, leaders, organizers, or managers of extensive drug networks. Now, the key in that is drug. However, that's not all it's designed for. Now, to prove a CCE violation, the government must establish that the defendant committed a felony violation of federal narcotics law, usually distribution or manufacturing of controlled substance. Now, again, keep in mind what I'm talking about, right? In this form, I'm using drugs, but the question was asked, can police be held liable? So stay focused. Now, I'm explaining the act and its original context. And what's up, twins? And again, yeah, absolutely, I want to say that is 100% correct. The Continued Criminal Enterprise Act does resemble racketeering influence corrupt organizations. Now, they are, but that's, again, that's where we're going with that, because again, that's what I was charged with. I was charged with 108 counts, and the top count was racketeering influence corrupt organization. The second count was conspiracy to commit racketeering, influence, corrupt organization. And the reason why they put both of those is because they couldn't tell whether who basically they said that we were the head, and they couldn't point to exactly who was doing what. So they named three people as the head of an organization, which were relatives. They were brothers. All of us are brothers. They're my brothers. So whenever they went to charging, it became an overcharge reach. And we exploited that context and their overzealousness. But again, it does sound like RICO. But when we're talking about the context of it, it is the reason there are similarities, but they're different. Because RICO is a multitude of crimes operated by members. And again, it can be. But again, the question is, can they be sued under the CCE? And that's why I said we got to stay focused and pay attention, because there are differences. Now, the violation was part of a continuing series of such violations. Now, catch what I just said, because again, with RICO, it's multiple violations that are done by separate people, and then it's internally covered up or excused. Let's use that, right? And it's okay because that is a policy or a daily operation. That's RICO. Now, the CCE is more controlled because it's dealing with one aspect that is then done as a continuing series. Now, give you an example of that. One man in Tennessee decided to file a lawsuit, get everything that he could from a state trooper that charged him with driving under the influence when he passed the field sobriety test because he's an agile young man. He passed the breathalyzer. He then passed the blood test, all of which showed 0. He was still charged. They attempted to prosecute him, until he filed the lawsuit. Now, once he filed the lawsuit, he didn't want money. He wanted records. What those records showed was now there was 15 that they've found so far that they've admitted to. Listen to what I said. When he did a records search, he requested records from not only that officer, but the Tennessee State Patrol. It became 15 that they've acknowledged. 0 was not under influence, was charged and attempted prosecution. So here's what I want you to know. This is where the CCE kicks in, because it's one act that is part of a continuing series of the same violation. Now, when I talked about the young man down in Houston, it was one act that went apart on the Houston District Attorney, which makes the state liable under the CCE because it was a constant, excused, one act, not a multitude. It was one. This is where the corrupt or the continuing criminal enterprise comes in. This is why it's different from RICO. Now, that this violation was undertaken in concert with 5 or more persons. Right now in Tennessee, they have noted 5 different troopers. One of them has 8 of them. 8 that they've acknowledged. Notice I didn't say that's all they found. They have 8 that was acknowledged from one trooper. But there is at least 5 that is in the investigation right now currently. The defendant occupied a position of organizer, supervisor, or manager with respect to those 5 or more persons. Now, the defendant himself in this is not the trooper. It is not any of the 5 troopers. Their supervisor is the one that is now got the spotlight on him. The problem is nobody's reporting that. But again, that's the CCE and the liability upon that. That the defendant obtained substantial income or resources from the enterprise. Each one of these officers that write one of these citations, they are given spiffs or special bonuses. Now, if you do contract and all this independent stuff, you understand what a spiff is. But the troopers, whenever they write a citation, whether it's this one or 100 others, they are compensated for it. Always understand that. So did they receive income? Now, it doesn't take all 5 to receive substantial income. It takes one. One received at least 8 bonuses in regard for this. One has already received the promotion, which means an increase in pay. So there was a substantial income and resources that was gained from that enterprise. Now, here's the thing. If a federal attorney, state's attorney, decides to prosecute the Tennessee troopers, not going to happen, but if they decide, the penalties are extremely severe. It's a mandatory 20 to life. Again, not going to happen, but these are the context of it because this is the explanation of the Continued Criminal Organization Act. Heavy fines, forfeiture of assets, not going to happen. And in some cases, death penalty, not going to happen. But again, these are the original context of how this was written. Now, here's the supporting case law. Because you know I don't do this without case law. Now, Garrett v. United States is a 1985 case held that the CCE prosecution is not barred by double jeopardy, even if the defendant has already been convicted of one of the underlying predicate offenses. Notice it said, if they've already done this, there's no double jeopardy attached because now they can be held liable for multiple counts, not just one. So if they're sued, multiple suits, and it's opened up and available because of Garrett. The CC is a separate offense requiring proof of additional elements. Now, Richardson v. United States, it's a 1999 case, clarified that the jury must unanimously agree on each individual violation that makes up the continuing series of drug crimes. Now, again, these are also part of the original context of the CCE. But when you're probably not going to make it to a jury. All of these Tennessee lawsuits from these these non-drunk people apparently, will be settled. They're not going to trial. They're not going to let this blow up to be any more than it needs to be. Now, it prevents conviction based on a vague or general agreement that some violations happen. Rutledge v. United States held that the CCE and conspiracy under 21 U.S.C. 846 are the same offense for double jeopardy purposes. A defendant cannot be convicted of both, again, the same as RICO, can't be convicted of RICO and conspiracy to commit RICO. So you either did it or you didn't. So anyway, United States versus Apprenda. Now, this is the influence. Although not directly about CCE, Apprendi affects sentencing. Any effect that increases the statutory maximum must be submitted to a jury, and beyond the reasonable doubt, this applies in CCE sentencing enhancements. Now, this is if you're charged with CCE and this part of the enhancement. Again, I'm going over the first part of the CCE in regards of the original context. Now, circuit courts is United States v. Aguilera. Circuit courts like the 5th and 9th circuits have clarified what counts as being an organizer, supervisor, or minimal. Minimal involvement does not meet the threshold. I'm going to tell you now, 15 acknowledgments meets the threshold. Defendants must exercise authority or control over others. A lieutenant, a sergeant, and a captain exercise authority and control over other troopers. Now, I hate to keep bringing that up, but that's the easy for right now because it's something that everybody's recognizing as available right now. So that's what I'm talking about right now. Now, the CCE Act is aimed at drug kingpins rather than street-level dealers. Courts have, sure, juries must agree on specific predicate crimes, but again, just because it's aimed at kingpins, you have to understand what the context of kingpin means. It just means part of an organization. They've created an organization in which they are profiting from. The easy again, the Tennessee Troopers. They're profiting by putting people or charging people with DUIs who are not intoxicated at all, and they are attempting to prosecute. Notice I keep using the words attempting because they're prosecuting until those people fight back. Because you look at one lady, she was charged and convicted, and the prosecutor knew she blew a 0. And her blood came back with 0. She still charged her. A couple of other ones, as soon as they went and got attorneys, they dismissed the cases. But again, the attorneys didn't, because they didn't, that's a consciousness of guilt. Because the attorney, soon as the prosecutor got the information, they had a choice. So when they made the choice to file the prosecution, and they then declined to prosecute once that person hired an attorney, that is an admission of guilt, because those who did not hire an attorney, they continued prosecuting. Always understand that. That's an admission of guilt because your actions show your intentions. Now, defendants can't be punished twice for conspiracy and CCC. Predicate convictions don't bar later CCE charges. It remains one of the most powerful tools the federal government has in dismantling large-scale organizations. Large scale, which is why I spoke about the Minnesota Police Department, which is why I spoke about the Blue Flu in Fulton County, which is why I spoke about Coffee City here in Texas. That's why I keep bringing up Buffalo, because these are large scale, because it's more than 10 people who are involved in it. You're looking at, well, I think it was at least half the police department in Atlanta. So at what, 200 people? 200 police officers? You look at Buffalo, it was 84 officers. Coffee City was 50 officers. It's 96% of Minnesota's police force. These are the things that I'm talking about. And what happened? The reason why I said this, go look it up. I actually spoke about bad police. I really put bad policing in the podcast, in the title of the podcast, Minnesota Police Department, because 96% of them were bad police officers. These guys had multiple disciplinary actions against them. They had multiple lawsuits against them. And this is 96% of the department, which is why they were trying to get out of it, because that's why you see a lot of officers resigning so they can keep their pensions. These things are not done accidentally. Now, the Continuing Enterprise Act, the CCE, 21 U.S.C. 848, was written for narcotics kingpins. Now, this is what I was just saying to you. But the statutory language is broad. It does not expressly exempt law enforcement officers. If law enforcement officers, individually or collectively within a department, meet the statutory elements, they could, in theory, be subject to prosecution under the Act. They can also be held liable under this Act. So you can sue them because of the statutory language that's in the CCE. This is what I was getting to, because that's what made this a great question, because the first thing that pops in someone's mind when someone thinks of continuing criminal enterprise, you think RICO, racketeering. So a lot of times when you're suing under racketeering, which does also allow for a lawsuit in federal court, it generally is not successful because the way you have to set it up, you have to understand there are several other layers that go along with it. Because even with the CCE, there are 4 different steps. Just like we were talking about with the Kingpins. CCE applies when a person commits a series of federal law felonies. The acts are in concert with 5 or more others. The person acts as an organized supervisor. It derives for substantial income and activities. If the police officers or an entire department are involved in things such as seizing drugs but reselling them, protecting cartels, running protection rackets, these are just examples. They're writing bogus tickets. These things are considered part of felonies because they're going outside of their oath, they're going outside their job duties, they're going outside, they're intentionally doing things that are not in line with policing. They're facilitating different aspects of it. They're using the badges, authority to protect shipments. Now, here we go. Falsifying reports, skimming seized assets. When you see police officers, what was it, Chapman in North Carolina, when they're stealing money from suspects, when, hell, like me, I was in DeKalb County. Yes, I'm saying DeKalb, DEKALB. These bastards stole, I had diamond earrings. I had 1 carat diamond earrings in my ear, and I had my number on my chain, number 25. I got arrested. I got bonded out within like 20 minutes. But they had taken all my jewelry. So when they gave me back 1 earring, and then they gave me back my necklace, so I told them, I said, hold on, where the rest of my stuff at? They go, well, that's what you came in here with. And I'm like, that's not even what's on this sheet. And then I held my wrist up. And she goes, what's that? I said, dumbass, it's in my booking photo. Both of my earrings and my big number 25 was on my booking photo. These things are things that they attempt to do. So when they stole that from me, the problem was they were gifts. I didn't pay for them, so they were gifts. So the compensation was as minimal as possible. And I should not have taken the money. Had I known then what I know now, I'd have taken this a hell of a lot farther, especially the way DeKalb County has constantly done me. Anyway, DeKalb County ain't shit. Anyway, let me keep going because that got personal. But again, those are things which count under that aspect of it. Now, profiting from the enterprise, kickbacks, payoffs, sales from seized assets. Let's say they take your car, and because you were driving without a license, they can't take your. Remember, I actually showed you. There's a literal there's a video and a podcast, an hour-long podcast that explains why asset forfeiture by police officers are illegal. It's not my words. This is law. Law makes it illegal. But if they're getting kickbacks like that's running the city, they're using it to police the city, that's a racket. They're profiting from that enterprise. They're profiting because they'll tell you here in Texas, there are a lot of cities here in Texas that are built. They operate on asset forfeitures because 95% of people don't fight back. And the 5% that fight back, 95% of them are afraid or don't fight for very long. Always understand that. Now, once you satisfy the statutory framework, the badge does not immunize them. In fact, the abuse of power may make the conduct even more egregious. This is what makes your case become more solidified. Now, even going through this, what you would do, you would either hire someone or you want to do it yourself, it's your business, or you call me and we help you step by step put together a plan for this. Part of that is going to be the police department or ring of officers qualify as enterprise under CCE. This again, the Tennessee officers. They qualify as an enterprise under CCE. The precedents, courts are allowed loose association or groups to qualify, not just cartels, and that's again under Garrett v. US. You can argue the badge creates a built-in organized structure. The chain of command, shared resources, coordinated cover-ups. And then you can also include the prosecution. Why? Because their actions show their intention and implied participation. Uh-oh. 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 This is why I love the words actors in concert. I love that because it's one of the most beautiful words that a cop said. Y'all are actors in concert. Absolutely. When I first wrote that on a lawsuit, it sent chills up I had goosebumps. Why? Because they will say it as a way of intimidating you. But when you turn, it ain't no fun when a rabbit got a gun. I became a 6'4", 300-pound monster that refused to back up because I was just the same monster they were. And what's made it worse is I told a dude one day, I said, I have little patience and I have rich friends. I don't mind becoming a monster because it takes a monster to beat a monster. And I always tell people that's why you hire someone else. You employ someone else because that monster can overtake you. It can become who you were. And again, I'm speaking from experience because I was married with 4 kids in my house. And even me and my ex-wife, we sat down literally years later because we split. It's now been a little more than 10 years. We split and she was like, well, maybe I could have done this or maybe I could have done that. And we could have talked. And I told her, I actually told her, I said, I'd found some emails that I was writing during the trial because I had forgot. I had 4 lawsuits going on in federal court at the time of my RICO trial. So not only am I defending myself here, I'm also suing people on the other side literally the same day. And I looked at the tone of those emails and it resonated because I was like, good God, who is this angry ass dude here? And I was like, oh my God, that was me. And then I started going back, looking through some of the motions that I wrote during that time. I was so angry because I was a monster. I was an absolute monster. And I was okay with it. And I told my ex-wife, no, we could not have stayed married because of the person I had become. It's not about talking. It's not about, I shielded myself because I actually wrote a thing on Facebook one day. And I wrote, you have to be willing to protect yourself, protect your family from the monsters that are there to hurt them, even if you are that monster. She never understood that because even my mother, she actually called me like, hey, what's going on, baby? Hey, you good? And I told her, I said, I'm good. I said, but I was talking about a time in my life where I had to get rid of me to protect my family. Protect those I love because it became a way of life. I was an absolute horrible person. I was willing to destroy everything I touched. Because I even talked about an eye for an eye, and one lady brought this up, and it was funny to me. I said, an eye for an eye, we both lose our sight. I said, but here's the problem. I'm willing to lose my eye to take yours. When you get to that point, when you tell somebody, I will take everything you believe you love, just because, when you're able to tell a police officer, I will move to Louisiana just to sue you, just to ruin your life and become a fool with a purpose. These are the things that you need to be cognizant of whenever I'm speaking about this, because going through this, you have to understand there is greater, but sometimes greater is ugly. Let somebody else be ugly. You see how ugly I am? I don't mind it. This is who I am. I've enjoyed this. But I also understand that sometimes the dragon has to be put in the dungeon. They got to throw me in a cave somewhere. I understand that, and I'm good with it. So understand, when you're going through this, the idea of doing this can be a lot much. And a lot of times you need someone else to be that monster for you. Now, when you're continuing the series of violation, right? Collect information. Collect information of the officers doing the felonies, falsifying records, which is easy because, again, they're using stock language, so they're not allowed to tell the truth. Taking records of the number of seizures, going and talking if you check out any reselling of narcotics, providing protection for traffickers, any of the other things that go along with it. Take note of all the federal violations that this officer or group is doing. Let me get a little water. Got a little parched. Now, under Richardson v. U.S., you need to show the jury can identify at least 3 distinct federal felony violations. I'll say that again. When you're looking to charge under the CCE or hold liable under the CCE, you need to show the jury can identify at least 3 distinct federal felony violations. Now, again, you will go after internal reports, whistleblowers, missing documents, missing evidence, and even go after any idea that was an FBI sting ever set forth. Now, DeKalb County, I'm glad I brought those up, because DeKalb County has had this done at least 3 times. So if you're going after a DeKalb County officer and doing much of the same thing, there are FBI records. Just know that. Make sure you request them. You go after Fulton County, there are FBI records. Make sure you request them because they are there. So understand this. The whistleblowers, they're there. Missing logs, internal reports, emails, any of that stuff, those things count in your favor when you're talking about the Continuing Criminal Enterprise Act and the holding them liable. Now, here's a great one. Supervisors, sergeants, lieutenants, or chiefs direct subordinates in these illegal acts. Now, remember I told you CCE gives a definition of what a manager in that context would be. Now, my favorite target for a long time until she was actually booted out was down in Arizona, and her name was Jerry Williams. Yes, I'm bringing her back up because she ain't been there for at least a year. Well, I think it's 2 years now. But Jerry decided that she was going to inform her lieutenants to tell the sergeants and make sure that everybody else went out and charged people, even though they were innocent, and put a gang enhancement on each one of the charges. Why? Because they were getting federally funded. Notice the compensation. Well, and she had 2 whistleblowers. She was under federal investigation, which is why she lost. She was willing to lose because all of these things, the Arizona Police Department, I can't remember which department she was under, I believe it was Phoenix, was under investigation because, one, under her reign, they were the most violent police department in the country for years. But then there was the gang enhancement that they were putting on innocent people. Not people that was in the gang, not people that was doing something wrong. Literal innocent people she was putting a gang enhancement on, and this is documented. The feds came in. So again, all of these things I'm talking about, the Phoenix Police Department, I believe that's where she was at. Jerry Williams at the time was the chief. So this could have been one of the charges or one of the grounds in which you can actually sue her under. Now, precedent. Courts require some exercise of control. United States v. Apodaca. Apodaca. A commander ordering patrol officers to falsify evidence logs has managerial control. A police chief telling her subordinates to enhance crimes to gang enhancement to receive federal funding has control, which then shows substantial income. Why? Kickbacks. Now, even with the resale of assets through asset forfeiture, that number counts. Salary enhancement tied to false stats. Because again, the bonuses received from writing these citations. Any promotions that are received after writing these citations. These are resources, include unlawfully obtained government benefits. I'll say that one more time. Unlawfully obtained government benefits. Now, piercing the shield of immunity. I gave you, I believe it's 9 states right now, including New York, that do not have qualified immunity. I'll say that one more time. There are 9 states. So now if you're going after a police officer in one of the states that do have it, such as Georgia for whatever reason, officers cannot claim qualified immunity because CCE is a criminal statute. They violated criminal law. The government has jurisdiction, so the federal courts have jurisdiction because of the federal offenses. Always understand that. This is why you go to federal court instead of arguing with them in state court. Argument: when police officers engage in ongoing crimes, they are not acting under the color of lawful authority. Basically, this is where you hear the terms, they're acting under the color of law, when they are not acting under any law at all, but are participants in organized crime. Read that one more time. They are not acting under any color of lawful authority, but they are active participants in organized crime. Thus, this is why the CCE is applicable in this state. Now, supporting case law. Garrett v. United States showed that large-scale ongoing schemes count as separate chargeable offenses. Going back to Tennessee, right now they have 15 acknowledged chargeable offenses. Richardson v. United States ensures a jury must agree on specific acts useful in providing repeat corrupt acts by officer. When you are showing that these people are not intoxicated, don't have drugs in their system, you are still charging them, you are still taking their assets, and you are still attempting to prosecute them. These are cognitive acts, and they are willful acts, and they're showing active participation in organized crime. This is what I think this question got ahead of itself because of how amazing this is. Because I immediately went to doing research when the question was asked, because I was like, this is her. That's an odd question to ask to start off with. I'm not gonna lie. Who's sitting down thinking of the Continuing Criminal Enterprise Act? Because again, like I said, just like Twin brought up, sounds like RICO. And again, honestly, I'd have just chalked it up to RICO. But again, I went and did the research, and I was like, oh my God, this is actually something. Because you can use it in protection against, and it's crazy to say that. You can use it as a tool to protect yourself from police officers. Oh yes, I had to pause for dramatic effect. Didn't even need a drink on that one. But now we go to Rutledge v. United States. It clarifies conspiracy versus CCE. Argue that the police conspiracy can ripen into a CCE charge when it's systematic. The Tommy Sotomayor question. Go listen to the podcast because it was an excellent question that he asked. You got the police officers who don't know law. You got the prosecutors who don't care about anything and they're cherry picking cases. You got a defense attorney that's not paying attention. They're not defending you. And then you have judges who don't care either way. And all of them supposedly are supposed to be working for your benefit, when in fact they're not. Let that sink in. The question was asked because there is a need and there's a meaning behind it. Because that's what makes it systematic. That is our justice system. Now, the United States v. Turkey, Turkett, Turkette. It's a 1981 case and it's RICO. But the analogy of it, because again, this is why I threw this out there. It held that both legitimate and illegitimate enterprises can be prosecuted if they engage in criminal activity. The police department is a legitimate entity perverted into an enterprise. The Tennessee State Troopers are a legitimate enterprise that has been perverted into an enterprise based on the actions of the troopers, the prosecutor, and the judges. Always understand that, because again, when defense attorneys come in, unless it's a public defender, they have been dropping these cases. So understand that is a conscious acknowledgement of guilt. Now, I'm going to go into the conclusion of today, but I'm also going to give you something, right? I'm going to frame for you an argument that you can make in this case. And let me get right. The Continuing Criminal Enterprise Statute was enacted to dismantle powerful organized narcotic operations. When sworn police officers entrusted to uphold the law use their authority to orchestrate a trafficking ring or any other distribution that is in kind a detriment to society, they become the very kingpins Congress intended to target. A police department engaging in systematic corruption satisfies every element of 21 U.S.C. 848. Repeated felonies, coordinated action with 5 or more individuals, hierarchy, control, and the substantial elicited income. No shield of law enforcement statute exists. I'm going to say that one more time. No shield for law enforcement exists. In fact, the abuse of public trust ingratiates the crime. To allow police officers to avoid CCE liability would create 2 classes of kingpins, those in cartels and those wearing badges. The statute, case law, and public policy demand equal application. And I'll see you guys in just a little bit.